The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome, everyone. Thanks for joining us for today's webinar, New Developments for Trust-Owned Annuities. The webinar will last approximately 15 to 20 minutes, and at the end, we will tell you how you can receive supporting materials from today's webinar. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Lineberg, and Linus regularly speaks at industry events. His most recent book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, which was written together with a CPA and a business broker, is now available for sale. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks so much, Jennifer. Hello, friends. Thank you for joining us today. We're going to talk about developments with non-qualified annuities and, a couple of things that have happened in the recent past that I think make non-qualified annuities more attractive to insurance carriers, to us, and also perhaps to our clients. Before we get into the meat of that, though, let's go ahead and decide what it is that we're going to talk about next month. Our webinars are the first Wednesday of every month. They're freely open to everyone, so feel welcome to invite others that you think might benefit from the sessions. The November topic will be the choice of three: HSAs in a nutshell. Second choice is a tragic beneficiary designation case, and then the third one is ethical issues with incapacitated clients. We'll talk about one of those three on November 4th. Let's go ahead and open the poll and give you just a few seconds to go ahead and vote on what your preference is for next month's webinar. Poll is open. Please vote. If you haven't voted yet, please go ahead and do so. It looks like things are pretty close. All right, let's go ahead and close the poll. Next month, we will talk about a tragic beneficiary designation case. Thank you all for participating in that part of it, and we'll look forward to next month's webinar on November 4th. So we're going to talk about non-qualified annuities today, and there's a lot to talk about. There have been a lot of changes. It could easily cover 2 hours, and we're going to try to limit this to just 15 minutes or so. But those of you who are on the call probably sell non-qualified annuities. You know how they fit. They grow tax deferred. They give clients some potentially slightly tax advantaged access to cash values, although the advantages aren't as great as permanent life insurance, for example. But there have been some uncertainties with regard to annuity taxation in the past. We're going to talk about those and kind of set the stage for those. And so as we talk about the appropriateness of annuities for our clients, I think it's incumbent on us to understand some of the subtle issues, some of the ambiguities, and be able to help our clients navigate through some of those issues. So before we talk about the latest things that have happened, let's take a quick review at how annuities work. And I'm not going to spend a lot of time on this, but I think it's important to kind of set the stage. Annuities seem pretty simple on their face. The client makes a deposit into an annuity contract. The insurance company, captures some expenses associated with the contract, and the rest is invested either at the insurance company's direction for fixed products, in some kind of equity funds for equity indexed products, or at the client's direction for variable annuity contracts. And if all goes according to the plan, the annuity grows, and its growth is tax deferred. And that's how it works. As distributions come out, they're taxed gain first generally. Also, pre-59.5 distributions are subject to an extra 10% penalty tax. The contract has some rules about how long it can last before the contract goes into payout mode. The players in an annuity contract are the owner. That's the party that exercises control over the contract. The annuitant, that has been the party that is the measuring life under the contract. These days, it's the owner. We'll talk about that more in a second. And then there's the beneficiary, and the beneficiary receives the death benefit when the annuity goes into payout mode. That's how it works. And annuity contracts are not always necessarily consistent with regard to who gets what and when. So on older contracts that were issued prior to 1987, those contracts are said to be annuitant driven. And what does that mean? It means that it is the death of the annuitant that causes the contract to go into payout mode. And if there are joint annuitants, the contract goes into payout mode at the first joint annuitant's death. Now, don't mistake an annuitant and owner. It is the owner that exercises control over the contract always. It is not the annuitant. The annuitant is, on these old contracts, the measuring life. The owner has the lifetime benefits that are associated with the contract, but it's easy to imagine circumstances where there's some tension between the annuitant and the owner's interest, and it can lead to unexpected results. Annuitant driven, primarily pre-1987 contracts. Now, the tax code says that all contracts issued since 1986 are owner driven. That people don't necessarily believe us when we tell them that, but it's right. The tax code says that any contract issued since 1986 has to be sent into payout mode at the death of the owner of the contract. And that's what we mean when we say owner driven. It is the death of the owner that drives the contract to go into payout mode. Now, it's also possible if there's a different annuitant, if the annuitant dies first, that the contract will go into payout mode. But the contract must go into payout mode under modern rules when the owner dies. And if there are joint owners, it's the first owner's death that requires the contract to go into payout mode. So if most contracts these days are owner driven, why do we need an annuitant? First of all, most state insurance codes require an annuitant, so that's kind of a legacy thing. But the thing that will be relevant for at least part of our discussion today is the tax code requires when we have an owner as a non-natural person, right, a business or a trust, which we'll talk about in detail, the tax code requires a natural person to be the annuitant and requires the payout to be triggered by the owner's or the annuitant's death. And again, we'll talk about that in some more detail in just a second. Now, the first thing that has changed in the recent past with regard to non-qualified deferred annuities is something that didn't affect NQDAs at all. It's the stretch rules that were changed as part of the Secure Act. The Secure Act limited how long a non-spouse beneficiary can stretch an inherited IRA or an other inherited account. And we get a lot of questions these days about what has happened to non-qualified annuities. And the good news here is that it is still possible, if the carrier allows, for a non-spouse beneficiary of a non-qualified annuity to stretch based on life expectancy. And so the post-death ability to continue to defer income tax result is better for an inherited non-qualified annuity than it is for, say, an inherited IRA these days, because stretch can be made to be longer for most non-spouse beneficiaries. So that's the first takeaway from today's session that I hope you will take away. Non-qualified annuity stretch is still available, and it makes annuities look better than qualified plans because of greater flexibility. So that's the first bit of good news from today. So let's talk about the real topic that we're going to talk about today, which is non-qualified, non-natural owners on annuities. And we get a lot of calls on this, and there are a lot of issues with annuities that have non-natural owners. So under Code Section 72U, it says that when an annuity is held by a trust or company, right, a non-natural owner, the growth every year is recognized as taxable income. So normally non-qualified annuities grow tax deferred. If it's owned by somebody other than a real person, then the annuity loses its tax deferred buildup. That's the first important thing to know. The IRS says in Code Section 72U as well that when an annuity is owned by a trust as an agent for a real person, then the annuity is considered to be owned by a real person, and you still get tax deferred buildup. And so it begs the question, well, when is an annuity which is owned by a trust, when is that trust treated as an agent for a natural person? So the following kinds of trusts are definitely agents for natural people. First of all, a grantor trust. So a grantor trust that owns an annuity is an agent for the grantor. A grantor trust is a trust that is treated as the grantor, the owner's alter ego for income tax purposes. The most common trust of this type is a revocable trust that I might put together to avoid probate. So the revocable trust that I put together for my own self, if I have that trust on an annuity contract, that trust is my alter ego for income tax purposes. I am considered to be the owner of the trust for income tax purposes, and so likewise, I will be treated as the owner of the annuity contract for income tax purposes. What other kinds of trusts are considered to be agents for natural people? A trust that is for the benefit of one individual. That's an agent for a natural person. What kinds of trusts are not agents for natural people? A charitable remainder trust or a lead trust. We've got charitable beneficiary and real people as beneficiaries under those types of trusts. And so you can't consider that to be an agent for a natural person. It's a complex trust, and therefore you lose tax deferred buildup on the annuity contract if it is owned by that type of trust. A trust that has one or more business entities as trust beneficiaries would not be to be considered to be an agent for a natural person. But we've struggled in more subtle circumstances where, for example, we've got a complex trust with multiple beneficiaries. So it's not a grantor trust, there are many beneficiaries. Or if we've got a sole proprietorship that owns an annuity contract, is the sole proprietor an agent for its sole proprietor? We don't know for sure whether that kind of organization would be considered to be an agent for a natural person. But the complex trust with multiple beneficiaries situation really has been the thing that we've kind of struggled with, and carriers have been all over the place on what it is they will and they won't do with regard to issuing contracts. So also some other unanswered questions: where the trust is acting as an agent for a natural person, does the pre-59.5 penalty tax apply? We didn't have an answer for that. Is it the annuitant's age that matters, or is it the person who is ultimately entitled to the beneficiary from the trust that matters for the 59.5 penalty? Or does something else matter? Is it the trust itself's age, meaning that the penalty tax is never avoided? Is that the situation? And carriers have erred on the side of caution, and clients looking for definite answers. We have carefully avoided giving them definite answers in those kind of circumstances, simply because the IRS hadn't given us direction and we didn't know the answers. So, that's what we've had to deal with to this point. So what's happened? Well, one more thing before I get into what's happened. We've had calls in the past from people who had an older client, perhaps 90 years old, and the client wanted to have an annuity issued, but the carrier wouldn't issue it for a 90-year-old. And so what they wanted to do is they wanted to use the 90-year-old's revocable trust, but name a different annuitant for the annuity contract and get the carrier to issue that contract under those circumstances. And so this is the example where we've got Carl, who's the 90-year-old grantor of his living trust. Carl wants his trust to buy an annuity because he likes the tax deferred buildup, but the contract names his 45-year-old grandson as the annuitant. And Carl, because it's his living trust, decides to take a distribution from the annuity at his age 94. Carl, pays the income tax because it flows through based on trust rules. But does the early distribution penalty apply? Is it Carl's age or the annuitant's age that matters in this case? Could the annuity even be validly be issued? Because if this is a grantor trust for Carl, and the carrier won't do the payout until the 45-year-old dies, isn't Carl really the owner of the annuity contract? Because this is an agent, this trust is an agent for Carl. And shouldn't the annuity go into payout mode on a 90-year-old? Those are the issues carriers and our clients had been wrestling with for years, and we didn't really have any direction. And so the good news is that the IRS issued on May 7th, private letter ruling 2020-31008. The PLR was issued to an insurance company that intended to issue 2 different trust-owned annuities. And the first trust-owned annuity that the carrier asked the IRS about was a grantor trust. And the beneficiaries of that trust were somebody other than the grantor and a charitable organization. And the question that the carrier asked is, well, if it's a grantor trust, can't we rely on the grantor to be the owner, essentially the owner of the annuity for many of the income tax issues? That was really the question that was asked. And so, and the carrier also asked about a complex trust. Carrier wanted to issue an annuity that was established by the grantor, but the trust was taxed on his own. And there was only one beneficiary of the trust who was not the grantor. And that beneficiary was named as the annuitant. And the carrier asked the IRS for rulings about that, asked about whether it could issue the contract and when the penalty tax would apply. So the specific questions were, who's considered to be the owner of the policies for the various provisions of Code Section 72? Would the contracts get tax deferred cash value buildup based on what they had? Which death would trigger the contract to go into payout mode? And would the extra 59.5 penalty tax apply? And so the IRS was specific in its answers. They said where the grantor trust was the owner of the contract would receive tax-deferred cash value buildup, even though one of the trust beneficiaries was a charity. And the service also ruled that the trust was a grantor's alter ego for income tax purposes, and that meant that the trust would be acting as the agent for that person. And for the purpose of the pre-59.5 extra penalty tax, it would be the grantor's age that mattered. And the grantor's status would control whether a disability exception to penalty tax was available, as would the grantor's age for 72Q substantially equal distributions would matter if the trustee decided to pursue those types of distributions to avoid the penalty tax. And the death benefit exception to the penalty tax would be triggered by the annuitant's death, even if the annuitant was different from the grantor, rather than the grantor's death. And so it was interesting that the IRS decided that it was possible for a grantor trust to name a different annuitant, and that the annuitant's death would trigger the payout and make that exception to the penalty tax available. And the stretch rules would be based on the annuitant's age rather than there is no stretch for non-qualified deferred annuities payable to a trust. It is the penalty tax that was the only issue that the IRS was saying that the annuitant's death would help avoid. So those were the answers with the grantor trust scenario. And the last bit was really kind of a surprise answer to many of us in the business. So annuitant's death would trigger contract payout, and so a different annuitant than the grantor in this scenario was also allowed, even though there's some ambiguity in Code Section 72U. So that's good news from the service for the carriers. Now, in the complex trust situation, because all the only beneficiary of the trust was a real person, the service confirmed that we got tax-deferred cash value growth. But where there's a complex trust, the service ruled that the trust itself could never attain age 59.5 or otherwise qualify for any of the 72Q exceptions to the penalty tax. But the annuitant's death would be a trigger that would mean the annuity distributions would avoid the penalty tax, but that was really the only circumstance under which the penalty tax could be avoided is after the annuitant's death when the contract went into payout mode to the trust. So the clarity provided by the private letter ruling is a blessing to us in our business. It is likely that carriers will take advantage of some of the new rules and some of the clarity provided by the new rules, even though a private letter ruling is not reliable authority. It is an indication about how the IRS is looking at this, and the IRS is pretty specific about how it is they're looking at this. So I think we can feel good about it from an advisor perspective and also from carriers' perspective that these issues have been clarified at least to some extent. So that's good news for us. There are some opportunities there for us to sell non-qualified annuities and trust situations that we may have been reluctant to address in the past. I would also say that as a reminder, both these things that we talked about, the Secure Act not affecting NQDA stretch and the annuities, the ambiguities over annuity taxation where there's trust-owned annuities, that's been cleared up. That's good news for us. It's good news for our clients. And there may be opportunities where clients have trusts where they can buy trust-owned annuities. It may work to their advantage. And as we work with their lawyers and accountants, we may be able to identify some of those advantages as we move forward. Thank you. I realize we moved quickly through that. As I said, we could easily spend 2 hours or more on that topic. But I appreciate you being with us today. And at this point, I will turn the program back over to Jennifer so that she can wrap us up. Jennifer?
Thanks, Linus, and thanks for joining us for today's webinar. And don't forget to join us next month on August 4th for a tragic beneficiary designation case. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You can also find our previous webinars on our YouTube channel. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.